Good afternoon, and thanks for joining Washington, D.C.-based Jennifer Schaus & Associates in our Get FAR Cited in 2020 complimentary webinar series. As you know, the FAR, or Federal Acquisition Regulations, is the rule book that the federal government must follow when making purchases. Our webinar series pulls from contracting experts to explain each part of the FAR. It is complimentary and recorded. We will post all of the recordings on our website and YouTube channel, where we have over 400 government contracting webinars available for download. A special thanks to our webinar partner in this series, the National Veterans Small Business Coalition Education Foundation. Please visit their website to learn more about the organization. We would also like to thank our friends at Open the FAR for their sponsorship. If your organization is interested in sponsoring the series or one part, please contact hello@jenniferschaus.com. And now a little bit about us. We work with primarily large businesses to help them navigate the federal marketplace. We work with both product and service companies as well as software firms. Our clients span the globe and include publicly traded organizations in a variety of sectors. We provide market analysis reports, contract administration, contract vehicle assistance, and more. All of our services can also be built into a training course for your team. Learn more about us at our website. We would now like to let you know about some ways to reach government and government contractors through us. We offer advertising and sponsorship opportunities through our weekly newsletter and also in our webinar series. For pricing or to place an order, please email us at hello@jenniferschaus.com. And as noted, we have over 400 webinars in our archives. As we continue to educate federal contractors, I would like to bring to your attention our webinar schedule for 2021. The full schedule and speakers are all confirmed. First up is a monthly series called the GovCon Live Q&A Cafe. This is a live webinar series held each month. These will take place on the second Friday of each month in 2021 at 12 p.m. Eastern. We have assembled a group of 4 panelists who are subject matter experts on a specific federal contracting topic. The panelists will make a short presentation about the topics listed here on your screen and then take your live questions about that topic. So for example, January, we'll kick off with panelists covering CMMC on Friday, January 8th. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab. Sponsorships are available. Please email hello@jenniferschaus.com for a media kit and pricing details. And for our second webinar series in 2021, we will be covering each part of the DFARS, or Defense Federal Acquisition Regulations. Similar to our current FAR series, this will be a weekly series dedicated to defense contracting, its rules and regulations. This series is complimentary and will be held on Wednesdays at 12 p.m. Eastern. We will run through the parts sequentially, which means that we start the year with DFARS Part 201 and finish with Part 252 at the end of the year. You can sign up on our website under the DFAR tab. And again, sponsorships are available. Please email hello@jenniferschaus.com for a media kit and pricing details. Now let's move on to learn more about today's speaker, Susan Ebner. You can find her contact information here. And today we are covering FAR Part 45 with Susan. Thank you so much for joining us, and the floor is now yours.
Thank you very much. I'm delighted to be here today. I want to say welcome to everybody. So we're going to talk about FAR Part 45 this afternoon, government property. You know, when we think about government property, we think about what is it, basically. So today we're going to be talking about what is the government providing to a contractor as government property. We're also going to talk about what the contractor is developing that constitutes government property. We're going to talk about how the contractor has obligations to manage and use that property. And last, we're going to talk about the reporting, redistributing, and disposing of that contractor inventory that constitutes government property. Next slide, please. Actually, next slide, because I've covered that. Thanks so much. Good. So government providing government property to contractors. Generally, contractors furnish all the property, all the things that are necessary to perform a government contract. As you know, responsibility is one of those concepts in government contracting where in order to be responsible to get an award, you have to have all of the capabilities, facilities, equipment, services, funding, financing, tools, etc., that you need to do the job. So the government, expects a contractor to come into a contract and have all of that, whatever it is, to perform the government contract. But here, this provision, if you have clauses like this, if you're looking to do a government contract to get government property, or the government says in a solicitation it's going to be providing government property, this is where they've made a decision that there's going to be property that's needed, that's got to be provided by the government, or that you will be developing in the course of this that will be government property. And in those cases, it's where they decide that it's in the government's best interest to provide that property, and the overall benefit of, them providing it, and all the costs of administration are outweighed by them having to buy it directly from the contractor. Hopefully it doesn't substantially increase the government's assumption of the risk, but on the flip side, as a contractor, you really want to make sure you're getting those indemnification and assumptions of risk from the government when you're getting government property. We'll talk about that a little bit later. And in addition, it's where the contractor basically needs this property in order to do what needs to get done under the contract. And we can talk about that as well. For example, I'm going to be doing something where I'm going to be repairing an aircraft. I can't repair the aircraft unless the government furnishes the government property to be repaired. Or there could be out of production parts that I can't get anywhere, but that the government has a stockpile of. In that case, the government might furnish that government property in order for the work to proceed. So those are certain kinds of things that come up in terms of what is government property. Next slide. So what is government property? So first of all, there's government property, which is defined under the FAR as all property owned and leased or leased by the government. It's government property that includes both government furnished property as well as contractor acquired property. Government property includes material, it includes equipment, special tooling, special test equipment, and real property. Government property does not include intellectual property or software. So then we talk about government furnished property, and that's like where the government is giving it to you. So as we said before, there's government property. It includes government furnished property, and it includes contractor acquired or provided, developed property. So the first one, government furnished property, is that property that's in the possession of the government and that's provided to the contractor for performance. In that situation, it includes things like spare parts. As I said before, we're going to be repairing an airplane, for example. We need spares to do it. If they're out of production or not available, the government may furnish that. And they do it, for example, the repair, maintenance, overhaul, or modification. You also could have government property where the government has, let's take an aircraft again, and they want to include in a specific system that was built by another company. They furnish it to you as government property, so that you can then install that in the aircraft or in whatever you're building, add on whatever you're building. And so that's the kind of thing that we talk about when we talk about government property. Next slide. Okay, so providing property to the contractor. There are several things you really need to know about this. I have actually had cases involving inadequate government property that was furnished for a contract. So key in terms of I'm getting the government property is that the government, if it's going to say it's going to provide it, it needs to provide government property that is suitable for its intended purpose, meaning that it will do what needs to get done for the government project. If they give you something that's broken, it's not going to be deemed suitable for its intended purpose. That's something you need to think about, because you may have a basis for a claim or for other government action, because you don't want to be held responsible if the government gives you property that is not suitable for its intended purpose. In addition, it has to be adequate and sufficient and timely. What does that mean? It means that they have to give you sufficient quantities of it. Not only must it not be broken, not only must it be suitable for its intended purpose, but it has to be given to you in sufficient quantities. And in addition, it has to be given to you in time for you to perform the schedule that you have bid on and obtained a contract to perform. If any of those things are not in tune, if they're going to do something where they don't give you adequate government property, they don't give you something suitable for its intended purpose, they don't give it to you sufficient numbers of it, so like they give you 10 widgets and you need 15 to do the job, that's going to delay your performance. If they don't do it at the time that they're supposed to do it, all of those things may properly come under another section of the FAR, which we're not going to talk about today, but it may be a basis for you to seek a change, say this is a change to the terms of my contract, could potentially be a breach of contract if it prevents you from doing your overall performance. And then you may be able to use this as a defense if they try taking action against you because you're not timely performing or adequately performing a contract. So knowing what property you're supposed to get, making sure that you put into your contract exactly what you're supposed to get, and then checking when you get it to ensure that it is suitable, sufficient, and it meets all the requirements that you need. Those are key things you have to worry about and think about as a government contractor. So this government property, what can you use it for? You're supposed to use it for the contract for which it's been provided to you. I've seen contractors get into trouble where they try using it for other purposes and they don't have permission to do that. You don't want that to happen to you. You want to make sure that if you get government property, you're using it for the purposes specified in the contract. If you need to use it for something different, let's make sure you get it in writing, get permission from the authorized contracting officer, because you can't use it for other purposes. That would be a misuse of government property. You certainly can't use it for commercial work unless you have approval to do so. In addition, the government property comes with warranties that it's suitable for its use, as we've said before. It says here in the clause, it doesn't apply to government furnished property and contractor acquired property. I would say the warranty of suitability of use and timely delivery does apply to government property that's being furnished to you in a contract. As long as you put it into the contract that you are required to have it, it's a condition of your performance. The government agrees. Those are things you have to worry about. If you as a contractor, though, are responsible for acquiring property that the government's paying you to acquire and that then becomes government property, this is something where you are not going to be able to hold the government responsible if it doesn't come timely, because you as a contractor have taken the onus on yourself and the contractual responsibility to acquire that property. If you don't act timely to get that property, you won't be able to say, I'm sorry, I didn't get it timely. It's interfered with my ability to perform. It won't be excusable where you've had control of getting that. There also may or may not be a rental fee associated with the use of this government contract property or the government furnished property. But stay tuned, because I think typically what we try to do is address that in the contract itself. Sometimes there are rental fees, many times there aren't. So you have to look at what the solicitation says. And when you're doing a proposal, really think about what is it you're going to need. And if there is going to be a charge, factor it into your contract. And last, but probably for my way of thinking, the most important thing is when you use or get government property, you must make sure that you have the tools needed for accounting for, tracking, and controlling that property. That's something you will be responsible for if you get government property. Next slide. So government property, where in a procurement would you find out if you had government property? Typically, it lists the government property that's anticipated to be provided. It probably is listed in the solicitation. It's certainly something you should address in your bid or proposal. And last, when you get a contract, make sure that contract specifies what you're getting. It will give you specifically the name, the part number, description, manufacturer, all the salient information that you need to know. What is this it that I'm getting? It also will provide the quantities and units that they'll give you. In some cases where they're giving you pre-existing government property, like an airplane, like a radar system, like a vehicle, whatever it happens to be, they will also give you that unique item identifier so you know exactly what it is that you're getting. Sometimes government property is furnished as is, sometimes it's not. If it's furnished as is, that should be a sound for you that I've really got to check this out before I decide this is sufficient for my needs. You want to do this ideally before you get a contract, because if the government property is not in a condition where it's suitable for the intended use, but you have accepted it in an as-is condition, then you may not have some recourses that you would have otherwise. I've seen people go and have inspections when they issue a solicitation and they say, we're going to be providing government property. They may say, come for a site visit. They may say, come and look. You want to look to make sure that if you are going to be receiving or using government property, that you know what the condition is and that you can account for that in your bid or proposal so that when you get the contract, you won't have this gaping hole of, gee, I'm supposed to do this and now it's going to cost me a ton of money that I didn't anticipate that I was going to need. Next slide. So where a contractor proposes to use government property, you have to cover all your costs. I think I've covered this in what I just said, which is if you're being given government property, you need to address what's it going to cost you to use that thing. If the government is providing it at their cost, they're going to deliver it to you, that's one thing. But if they're going to say, here it is at X site, and you're going to have to bring it to your facility, you're going to have to do the work that you need to install it, rehab it, etc., you want to make sure that you're capturing those costs in your contract. You also want to make sure that you're identifying when are they going to provide it to you, and you're going to identify how you're going to manage the system. You know, in government contracts, we have something called business system rules. The business system rules, which are covered in the FAR, really are very key to contractors getting acceptance, getting payment, etc. So where there's a business system rule, one of them is material management and control systems. And when we talk about government property, that property management system falls under the, you know, the rubric of material management and control systems, CMMC, which is in the business systems rule. The government, if you do not have a sufficient material management and control system, and they audit you and find there's a deficiency, they can withhold payment from you until you cure that deficiency. So, you know, another watchword here is to think about, I'm getting government property. Maybe upfront, you want to make sure the government knows what your property management system is, how you're going to plan on using it, and they accept it. Because if they say this is sufficient and then later they say it's not, then there may be a basis for you to, again, have some recourse if there's a problem. Next slide. So what the government, as I said before, they're going to decide, are they going to give you government property? They're going to be looking at whether there are any charges or cost savings if they give you that government property. So if they're going to give you a contractor government property, do they have an obligation to give other contractors government property? No, they don't. For example, you may have government property that you got from a previous contract. And you may then say, gee, I'm going to do this other contract. I've got this government property. I don't need it 24/7 for the existing contract, or that contract is over. Government, I propose to use this government property in this new contract. If you're going to do this, what the government is going to want to do in its evaluation is ensure that those cost savings and charges are identified, that any potential unfair competitive advantage is kind of like dealt with, because you want to make sure that you have a fair and level playing field. So those things will be things that if you look in your solicitation, you're going to have provisions that are going to ask you to explain if you're offering government property, what is it that you're going to be doing? What kind of charges are you going to be including in the government contract? What kind of cost savings are you going to be achieving? And then they're going to be evaluating that and factoring it into their contract. In addition, as I said before, when you're putting in a proposal, make sure you lay out what your property management plans and methods are for that so that they can decide whether or not this is sufficient. Next slide. So traditionally, you get government property, you have a cost reimbursement contract, you have a time and materials or labor hour or fixed price contract, and you're able to get government property, and the risk of loss remains with the government. Meaning if you do everything you're supposed to do and the property falls apart, that risk is on the government. You know, the government then would have to replace the government property if it breaks, you know, unless it gives it to you as is, in which case there may be other issues that have to get dealt with. But traditionally, contractors will not be held liable if something happens to that government property and they haven't done something affirmatively that will abuse them. You know, that they find the contractor has somehow abused this property and hasn't done it appropriately. Where there's a loss of government property, the contractor may be able to recover the value of the property, the repair, replacement, or other forms of restitutions. If the government assumption of risk of loss is revoked. Where, as we said before, this property management and control system has not been found compliant, and then it results in a problem with the government property, then the government may very well file a claim against you. If it does win on that claim, it may obtain financial restitution. That money, where does it go? It goes to the Treasury Department, unless there's statutory authorization for it to go somewhere else. So loss of government property may result in contractor liability. So obviously, watchword here is make sure you have the right systems and control. Government has accepted them, they're sufficient, and so that government assumption of risk will remain in place. Next slide. So contractor management and use of government property. As we said before, you're going to have to maintain property management policies, procedures, and practices and systems to comply with requirements. So what does that mean? That means that you need systems that if you're going to be taking in the government property, you have a policy and practice for how are you going to handle that intake of government property? Where are you going to store it? How are you going to know you have it? Who's going to be responsible for accessing it? You want to make sure that the government property, if something happens to it, that you have that chain of custody, that you did everything in accordance with your property management system. So if there's some problem, it's not something where you have assumed the risk of loss, but the risk remains with the government. You're responsible for, doing your part for this property management, and the government is responsible for doing its part in terms of ensuring that your system complies and that you are properly handling that. So you may, if they find that there are deficiencies, be asked to correct deficiencies in the process. You may be asked to provide a corrective action plan for fixing the process. And you've got that risk of loss, as we mentioned before, that the government may say, we no longer have the risk of loss here. It's revoked now because you didn't follow the appropriate business systems compliance. And so you now assume the risk of loss here of any damages that have occurred, and the government may reserve its right to file for additional remedies as well. Next slide. Contractor management and use, sorry about the typo here, of government property continued. Authorizing the use and rental of government property. So in some cases, government provides you property rent-free. Some cases, it assesses you rental charges for the use of the property that you retain even after the contract is over. You can actually, as I said before, you can ask for permission to retain the government property after your contract's over. Typically, though, the government has an agreement with you that lays out what it is that you're allowed to do. Some of the things that you're allowed to do, if the government approves it, is to use it for commercial purposes. But you can't use it if it's not an authorized purpose, if the government hasn't consented to that use. And traditionally, when we see those agreements where the contractor is allowed to use this, they also have an obligation that if a government contract comes in, or a grant, whatever it happens to be, where there's a government need to use that property, that the priority goes for you using that property for the government purpose. The other purposes, those commercial, non-governmental purposes, they fall lower down in the tier, because the priority is always, we always do the government work first. We always get that government stuff done. So those are watchwords. I mean, you'll see on this list, one of the things that may be allowed to be done is to allow you to use the property for IRAD, independent research and development. That could be something pretty important to you. So knowing that you're able to do that is something that you want to make sure that you go through all the different brackets to get that approval. I have a note at the bottom that says non-government use expected to exceed 25% of use requires prior head of contract agency approval. And what that really means is, as I said before, government use comes first. If you're going to be able to use it for non-government purposes, you've got to identify it. If it's going to exceed more than 25% of the time that that is available, that's something that's going to have to require a higher level of approval. Next slide. Title to the government property. So even when the government sends the property to you, it always retains title to the government property until it's finally disposed of. We'll talk about that in a little bit. For fixed price contracts, contractors may retain title, to that property that they have acquired or fabricated under the contract. But that's typically got to be written into the contract, so you really need to know, do you have that? We see that kind of thing, particularly in situations where you have to acquire certain equipment to do certain, testing and control work or whatever. And at the end of the contract, you're left with, okay, I've got this thing for testing. I may need it again for future contracts. Will the government say, it's still my government title property, give it back to me? Possibly. Or they may say, you're going to have other contracts, we're going to let you keep this property. If they let you keep this property, they may very well say, I need to get compensated for this. So typically it's, what's the value of that property? And you may have depreciation because you've been using it. Let's say the contract was 5 years long. You may have straight line or accelerated depreciation. You will arrive at a agreed to price and potentially have to pay for keeping that government property and obtaining title. Those are things we'll talk about a little bit later, but just bear in mind, if you get to keep the property, it could be they decide they're going to let you remain in place, or they decide that they're going to actually be conveying title to you, and there may be costs that are involved. For cost reimbursement and time and materials contracts, the government typically receives title to anything the contractor's been reimbursed for, as I said before, but as I said, they may also decide that they will allow you to keep it. It depends. And you're going to hear the it depends a lot. Next slide. Subcontractor property management. So the government contractor, typically the prime contractor, is the one who gets the government property, but sometimes prime contractors need their subcontractors to do things as well to the government property, or to use the government property for the purposes of the subcontracted portion of the work. Where a prime is going to be doing that, they have to notify the government. In other words, the prime just can't go and send this stuff all different places. There has to be organization. I've heard from clients, it's like, I just need to do my job. Why are there so many impediments? And the fact is, if you run through the different brackets of control, approval, approval of the way it's being handled, that government assumption that, if there's a problem, they're still involved, is still in place. But if you're not paying attention to that, then the risk is that if something is innately wrong with the property that isn't caused by something you've done, that the government could say, you didn't follow the rules, you're responsible for everything, you bear the risk of loss when you gave it to that subcontractor. So you really want to go through those procedures for making sure that you're handling it the right way. The contracting officer, typically we have administrative contracting officers as well as procuring contracting officers. When you're in a government contract, you have an administrative contracting officer. That administrative contracting officer is likely going to be the Defense Contract Management Agency if you're a defense contractor, and it still may be the Defense Contract Management Agency if you're not a defense contractor, or it could be another particular, whoever you're dealing with, agency's administrative contracting officer. And they will typically identify the property administrator, from the government side, who is that contract administration office that you have to be dealing with. When it's a subcontractor, you're typically working with the prime contractor's, contract administration office. However, let's say the subcontractor's in a different state, different locale, it may be that another office may make more sense to oversee that. And if so, then delegating that support administrative function is one you have to go through the hoops with to make sure you get that right. Sometimes contracting officers will just go ahead and do things to assign it to different entities. The FAR Part 45 allows for a challenge to these findings. I'm not sure I've ever seen a situation where there has been a challenge. Usually contractors can work this stuff out, but just bear this in mind. Next slide. This is probably hard for you to read. At your leisure, you'll have a chance to kind of blow this up. But this is the SF 1428, which is the inventory disposal schedule. So when we're taking government property and we're getting ready to dispose of it, this is the schedule that you're going to have to use. It provides for, the contractor preparing it, and it goes through the process of their plant clearance officer reviewing and accepting it. So it involves transfer of the property. It involves donation of the property, where the property is no longer required for continued performance of the contract. So it does not apply to certain things. Those things include scrap, like scrap other than aircraft parts. If it's an aircraft part, that's different for many reasons. Aircraft parts may be available, but scrap, let's say what you've got is you've gotten giant metal sheets and you're disposing of, the little leftover scraps after you cut out what you needed. That's the kind of thing that may be on this list. Next slide. So this is another list. A lot of lists when you deal with government property, but this is something you really have to kind of focus on. I just have to follow the rules on this. These become very important to just make sure that at the end of the day, nobody says you didn't properly account for, manage, and dispose of the government property. The SF 1423 is the Inventory Verification Survey. This is a document that gets prepared that lays out all of the place, what am I doing? What do I need? What was purchased? What was used? What was unused? Who did it go to? It's a screening process. And so knowing this, it's like the disposal schedule of what do I have to do to get rid of this stuff? And there's a lot of different questions in this that you have to answer. Next slide. So sometimes what happens is the government decides we're going to abandon this property in place. So on that schedule that we saw before, that may make it to that schedule. So in some cases, for example, the scrap, the government may decide I'm going to abandon it in place. The testing equipment, I'm going to abandon it in place. Or it could be something where it's destroyed in the process of being used, that's just a natural consequence of, gee, I'm testing missiles for their capability. I get government property of, the armaments, and then I go and I explode them to see what the ramifications are. And guess what? There's no more armaments that are left. It's been destroyed. So addressing that disposition and what's happened to it is all part of the government accounting for all the things that it's giving you to make sure that it's being properly handled and disposed of. Sometimes there's stuff that's not abandoned and it's not destroyed, but it can be reused again. So how does it get reused? Well, if you as a contractor aren't asking to keep it, or the government's not giving it to you, it could be something where it's transferred to schools or nonprofits for educational use. I mean, if you've ever gone to one of those technical kinds of areas, whether it's like a Carnegie Mellon, or it's an Eastern Academy, or one of those other nonprofits or school, and they may have, for example, airplane parts, or they may have, military vehicles, and those things have been provided for educational use to train people who are potentially going into the different areas so that they have equipment to use. So that's something that's also accounted for under these contractor inventory and distribution schedules. Note that the General Services Administration somehow has a finger in these pies. Sometimes it doesn't, but sometimes it does. The rule actually provides that if the reuse is within the government or being donated, you need to report it to the GSA. And that's because GSA is the warehouse for all government stuff, unless it's being used affirmatively by the different agencies. So just another fill up in the area of reporting, redistributing, and disposing of contractor inventory. Next slide. Disposing of the government property per agency procedures. If you're reporting to GSA, the disposition is the property is determined appropriate for abandonment or destruction. That applies the federal management regulation. It's not written down here, but it is 102-36.305 or 41 CFR 102-36.305. Those federal management regulations lay out the procedures for abandonment or destruction of government property. Sometimes property is furnished to non-appropriated fund activities. Sometimes it's foreign excess personal property. Sometimes it's scrap, but not airplane scrap, as we said before. Sometimes it's even perishables. It could be, that you've got government property that is food that has been delivered for food services that are being provided for contractors who are providing emergency food services during firefighting season. And you've got leftover stuff. I didn't use all my broccoli or whatever. And that's, believe it or not, disposition of perishables, what's left, subject to spoilage or decay. I gotta write down what happened to it so that they don't think that there's some fraud, waste, or abuse. Trading stamps, bonus goods. Gee, it harkens back to my days when I was a Navy trial attorney, and you used to go and fly on the Eastern Shuttle to go to New York for work. And every time you went on the Eastern Shuttle, they gave you back a little coupon, and the coupon was for $25 off the next flight. And, if you're a government contractor or you're a government employee, you can't keep this stuff unless they say, yes, you can keep this stuff. And what they usually say is, no, you can't keep this stuff. Give us those trading stamps, give us that coupon, because we, the government, may use it. Whether they use it or not, this is not something you get to keep unless the government approves it. So a word to the wise, always be wary of this area. I've seen this in healthcare issues where pharmaceuticals are being bought. There have been DOD memorandum on this, that if they give you back coupons or discounts, you have to give those to the government. This is the same kind of thing. If you get something like trading stamps, bonus goods that are worth something, you've got to give it back to the government, notify them you have it, and get proper disposition of that. Hazardous waste and toxic materials, obviously, those are things that are controlled anyway. Controlled substances always have to be disposed of properly, and you have to have a record of how you're disposing of them. Sometimes, next slide, sometimes they're nuclear, sometimes they're toxins. We could have government property that could be a strain of virus that's being given to, a laboratory so that they can develop the next vaccine for, cure COVID, for example. Those kinds of things, if there's leftovers, that's potentially toxic or hazardous property, you have to dispose of it properly. The government agency will give you direction in those situations where you get specific direction from a government agency because it's property dangerous to the public or classified items or otherwise sensitive to national security. You must comply with the agency procedures. Always see if you can get things like this in writing so that you know exactly what it is that you have to be doing to be compliant. I don't know how many of you will have to deal with nuclear materials, but if you do, there is a provision in this section of the FAR that addresses that. And I would dare say that if you are subject to the Nuclear Regulatory Commission, that also comes under the aegis of the Department of Energy, and there are other applicable federal and agency regulations that you have to pay attention to. So if you have that kind of situation, no, you really need to know what the rules are. Next slide. So I want to go and get rid of my leftover contractor inventory of government property. So in addition to filling out the forms that we talked about before, there's a screening period to address this. It's like the government has built in an entire process for what do you do to address this government property. And as I say on the screen, first you tell the government, I got this property, and then they figure out, do we need this property somewhere else? They have 20 days to do that. And then the plant clearance officer submits a revised schedule for reporting and addressing the disposition of the property. So if the government comes back to you and says, yes, I need this over here, you gotta take the steps to get rid of it. But if you ask for the transfer of property, that may be something that they grant, but they won't grant that typically until after they figure out, are we gonna send it to another agency? Are we gonna send it to another contract? Are we gonna send it to an educational facility? What are we gonna do with this? And once they figure out what they're going to do, then they will let you know, and then all these forms have to be filled out in order to dispose of the property. So days 21 through 46, this is exactly what I'm talking about. The screening of the property, special test equipment, special tooling. Those are things that they may dispose of. As I note here, DOD and NASA, they really consider reuse and transfer only within their agency. For many reasons, they don't want that stuff going outside of their agency to other agencies. So they decide if they're going to keep that stuff or not internally. In some cases, as I said at the beginning of this, contractor acquired or produced property, meaning you had a contract, the government paid you to buy government property, or the government paid you to produce government property. In some cases where the agency doesn't need it anymore, it may sell it to you at what I say is the acquisition cost, but which I believe is really after it's been depreciated, because you're obviously not buying new property. Next slide. So other categories that have special rules, and they're laid out in Part 45 and other places, include, believe it or not, printing equipment. Why printing equipment? Well, I actually think there are many reasons. First of all, we see with Xerox equipment, a lot of the copying equipment, it's now smart. And so the smart equipment contains computers, chips, but it also contains leftover information that is within the smart equipment. So if you just disposed of it, I'm sending it to the trash, or I'm giving it to somebody else, and then they went to go and use it, and they went and accessed the memory, they might very well get copies of the government documents that have been printed on it, or other information about where it has been and what it's been used for. That kind of stuff is obviously not something the government wants you to be able to have other people who haven't been screened have access to. So typically, for example, you see rules that are special on disposition of printing equipment, including potentially removing that memory from their or other computer equipment so that it's no longer there, and otherwise scrubbing it so it can't be accessed. Next slide. So reporting and redistributing, excuse me, government inventory where it's not requested by the contractor agency and they abandon or destroy it, you may be able to dispose of it on your own as long as it doesn't require demilitarization or pose a danger to public health. So demilitarization means, for example, I've created armaments and I have all of this pile of leftover chemicals that could be explosive. I need to render them harmless. So if the government abandons or leaves the property there, you may have an obligation to address the safe disposition of that property. So that's something that may occur under this process. A plant clearance officer or authorized official can direct you to destroy the government property, abandon non-sensitive government property at your facility, or even abandon sensitive property, but only with your consent. If there is a cost to this, I think you really need to be strategic and think about that up front as soon as you can, because you want to write into the contract if there are going to be costs that you're not going to get paid. You want to know upfront so you can factor that into the price of your contract. These ultimately may be things that have a cost, and so if you don't, they may very well say they're not paying for this. So you really need to be thinking about these kinds of things up front if you're getting government property. A higher level approval is required to abandon or destroy property where estimated cost of continued care exceeds proceeds from its use. So that's kind of another one of these. Does the government keep it? Is it going to cost them more to ship it? What does it do? If the government's going to not do something, they have to give you a notice of abandonment and destruction. You want that as much as they want to give it to you, because if you're going to be able to sell it for scrap or you're going to be able to use it for other purposes, you want to know that you have the right to do that. So getting that notice of abandonment, destruction, or as we said earlier, of potential sale, you want to have that documented. Next slide. So here we are, sales of surplus government property. In some cases, the agency may ask you to dispose of that government property and give them back the proceeds. Unless you've done something else to write it down in your contract, that may very well be what they give you. In other cases, they may just abandon in place, and if they do, and then you go and you sell it for scrap, that may be something that you're entitled to keep. Other things that I think are interesting are FMR 102.39. That covers situations where you've got specific government property, but then you decide you need additional or different government property. And in those cases, the government may very well do an exchange and provide you with additional property or the ability to get additional property where it's needed. Next slide. Yet another form, the SF 1424 Inventory Disposition Report, that deals with situations where you are selling or exchanging government property. As I've heard before, there is a form for everything in the government almost. And so this is yet a different form, and this one applies where you are disposing of your property through an exchange or sale. Next slide. We talked a little bit before about scrap disposition. You have to have specific procedures for your disposal of scrap. So when we go back before, we were talking about the material management and control system, this is another piece of the puzzle. You really have to be thinking about contractor management. What do I do? I'm making this part, I'm going to be cutting out, the sheet of metal, I'm going to have leftovers. How am I going to control for and address this? In some cases, for example, you're dealing with situations where you could have metal scrapings that are floating in the air unless you have a proper system for effectively disposing and capturing them. So things like that need to be controlled for. Classified or controlled materials, radioactive materials, these all have a place in your management plan if you're going to be handling them. So again, upfront, addressing in the beginning, what do you need in your plan? What do you have to factor in? Those are all very important pieces. And then at the end of the contract or during the contract, disposing of this scrap, that's part of what you need to worry about and think about. And this is what Part 45 addresses. Next slide. This is the government property slide. This is like the clause. The clause goes into all cost reimbursement and time and material solicitations and contracts. It also goes into labor hour contracts when property is expected to be furnished. And it goes into fixed price solicitations when the government contemplates it's going to provide government property. It says specifically what the government's going to do. It says what the government's obligations are. It says what happens if it doesn't do it. And you'll note here, for example, if you look at item number D2, delivery or performance dates, here are the dates that we're supposed to give it to you. Item number Romanet I, if the property is not delivered to the contractor by the date stated in the contract, the contracting officer shall, upon timely written notice by the contractor, consider an equitable adjustment to the price. Again, when these things happen, you're dealing with government property and the government is furnishing you something that isn't what it's supposed to be, that is not furnished in adequate or suitable, sufficient quantities or in time, you have to timely file a written notice and request to seek assistance. And that's what is included in this clause. So just taking a look at this clause and being aware of what the changes are, where you might have an opportunity to be paid as opposed to in the situation where it's as is and you have to refurbish, repair, replace at your expense is important for you to look at the time that you're bidding on the contract, and then in performance, important to understand this clause and know when you have an obligation to report. Next slide. This clause also includes the contractor plans and systems. So you have this clause, again, sorry to beat this horse into the ground, but Literally, the material management and control plan has to cover the following things if they apply to you. Acquisition of the property, receipt of the property, records for material management and control of the property, physical inventory. This is really important because when I have seen contracts before where there is government property, the issue becomes, where do I store this government property? Not only where do I track it, but where do I store it? And very often there may even be a cost for that. Some government property can't be left out in the rain, it'll corrode. Some government property has to be kept under lock and key. So having that process in place, knowing what you need to do ahead of time, very critical. And as item number 7, relief of stewardship, responsibility, and liability, this is very key to building into that plan that gets approved by the government, what your responsibilities are, what the government's responsibilities are. Next slide. So 52-245-1G, systems analysis. This is where, as I said before, government has the ability to come in and access and review and inspect. If it determines that there is a problem, then the government may come back and seek an equitable adjustment, file a government claim, request corrective action, etc. If the government takes steps that are more than is reasonable, that may become something that could potentially be the basis for a claim, but everything is based on the specific terms and requirements of the contract and what specifically has been done and whether or not, given what's been done, if there's a breach of the contract. Notably, the equitable adjustment clause under the government property clause says the government shall not be liable for breach of contract following a delay in delivery of government furnished property, delivery of government furnished property in a condition not suitable for its intended use, and decrease in the substitution of property, or a failure to repair or replace. I don't know that I agree with these things because this is written into the clause now, but in accordance with the changes clause, if you are required under the contract to be given property suitable for its intended use in sufficient condition, the case law out there says you have ability to get recourse from the government. So forewarned is forearmed. Make sure you put in the contract what it is you're required to get and make it an essential term of the contract. Next slide. These are just 2 additional clauses: government property installation operating services and use and charges for government property. We've talked about them in general terms. This is just to let you know, here's where the clauses are. Next slide. So takeaways from this: government property may take many shapes. It could be government furnished property. It could be property that you're acquiring. It could be property that you are actually producing to be used. Its intended use and requirements should be identified during the procurement process upfront as early as possible and memorialized in the contract. You should also include a recognition of what the costs are, the responsibilities are, and what would happen if there is a problem, so that those things make it easier in the event something happens that was different from what was anticipated. You want to be able to find that you have some recourse to this. Where problems arise, there may be routes to recover and address those problems, the costs and the risks. There may be claims. There may be other things that you can do. So I hope that this has been useful to you, that you've learned a little bit about government property. If you have any questions, please don't hesitate to contact me. Next slide. Thank you for joining us.
Thank you, Susan. Thank you, Susan, for a great presentation. And to our audience members, we thank you again for participating with us. If you have questions about this part, please contact our speaker with the contact information seen on your screen. And if you have any questions about federal contracting or need assistance with any of our services, please contact us directly. Thank you again for joining us. This concludes today's webinar.